Real estate investors love spreading myths, rumors, and old wives' tales about LLCs. Inexperienced investors have these dreams that LLCs provide you magical shields to protect your personal assets and your rental properties from any lawsuit. While there is some truth to that, you need to know the whole truth. I've sued hundreds of investors and I've defended hundreds more. So today I'm going to dispel the 13 most common LLC myths. And let's start with taxes. Myth number 1, forming an LLC will save me from federal income taxes. Listen, an LLC is a pass-through entity, particularly if you use a single-member LLC, which is treated as a disregarded entity. This isn't really a bad thing. In fact, it's a good thing many times because you want your tax benefits, particularly if you invest in rental properties, you want them to flow up to your personal return so that you can write off all those wonderful deductions. However, people seem to think that just because they set up an LLC, somehow it will protect them from having to pay those federal taxes. The reality of that is absolutely not true. Essentially, it means, in the eyes of the IRS, they're going to treat you as if the LLC didn't even exist. The one exception is S-Corps. S-Corps can save you money in taxes if you set them up right, because they can help you from paying too much in self-employment taxes. Myth number 2, if I form an LLC in a certain state, it will save me even more on my federal taxes. I see people trying to shop around with other state LLCs, and many times they'll end up paying quite a bit more for compliance and setup and reporting for those LLCs in those different states, so that whatever they think they're chasing in tax savings, they end up losing because of all those additional expenses. Myth number 3, forming an LLC in a different state than mine will help me avoid my state taxes. Listen, I get it. Many people are tempted to set up an LLC in a tax-friendly state, like Wyoming or Nevada. The problem is, it doesn't really work this way at all. If you set up an LLC in another state, you're not going to be able to avoid paying taxes in the state that you're in. For example, let's say you're in the state of New York, and maybe you run a short-term rental business in that state. And so you decide you don't want to pay New York state taxes, so you set up an LLC in Wyoming. Can you actually avoid paying state taxes in New York now? No, you can't. You can't simply just set up another business in a different state's LLC and avoid paying your state income taxes. Why? Because you are still engaging in New York state-based transactions. Anytime you're involved in a transaction in the state you're located in, you can't just escape the tax by moving your LLC into a different state. Furthermore, if you form an LLC in another state, you're still going to have to register it in your home state. This usually means you're going to be subject to more fees and compliance requirements and end up losing all the benefit you think you're trying to chase. Myth number 4, S corporations are at a higher risk of being audited by the IRS. One of the benefits of an S corporation is that you do not have to pay as much in self-employment taxes, but simply because you obtain that benefit with an S corp doesn't mean that you're at a higher risk of being audited. All that is necessary to avoid unwanted attention from the IRS with an S corp is just to make sure that you're paying attention to your payroll allocation each year. There, you're no more at risk than any other LLC to be audited by the IRS. Now, let's talk about LLCs and crossing state lines. Myth number 5, LLCs are the same everywhere. One of the most common misconceptions people think is that forming an LLC one place is the same as forming it somewhere else. In reality, it's quite a bit different. Some states can have as low as a $10 filing fee. Other states can be as much as a $900 filing fee. So not only the filing requirements different, the compliance requirements can be different, and maintaining them in every way can be quite a bit different. For example, New York State does something really weird. They require people to do a publication requirement before you can even set up your LLC. In other words, you have to let everybody know through a newspaper that you're planning on starting your business with an LLC, and you have to do this publishing requirement before you can ever complete the filing. Furthermore, LLC protections are not the same in every state. In some states, you can obtain both privacy and charging order protection, but in other states, you might not obtain any of them, so your LLC may be very little value. For example, California, not only do you have to pay a $900 filing fee, but you also have no privacy, you have no real protection in your California LLC. Whereas in Texas, you can have charging order protection in your LLC, which means they can't take your property from you if you get sued and you lose in that LLC, but it has no privacy. So understand the difference here. There's quite a bit of difference in protection and privacy from state to state. Myth number 6, you have to be a U.S. citizen in order to register an LLC. Do you really need to be an American citizen in order to register an LLC in a particular state? You sure don't. Do you have to actually live in the United States in order to set up an LLC? Nope. In fact, when it comes to LLC ownership, the only real distinction between citizens and non-citizens is when it comes to taxation. Because non-citizens do not have a social security number, they must register a tax identification number, a TIN number. Why? Because the IRS wants you to pay taxes. So if you're not a U.S. citizen, once you obtain your tax identification number, you can now register this so that the government can get their taxes from you too. Beyond that, U.S. citizen or not, LLC ownership is essentially the same. Myth number 7. Setting up a foreign LLC allows me to borrow another state's beneficial laws. If I own a property in a state with very poor asset protection laws, can I go throw my property into an LLC in a state that has great laws? Unfortunately, no. Good example of this. If you own a property in California, could I just go throw my California property into a Wyoming LLC and now I can borrow Wyoming's laws? Unfortunately, no. If you get sued, you're going to be hauled into a California court in front of a California judge, and California law is going to be applied to your lawsuit. You cannot borrow another state's beneficial laws if you find yourself in a California lawsuit. Now, let's talk about how LLCs keep or don't keep your assets safe. Myth number 8. LLCs don't need insurance. An LLC is a great first start to protecting your assets, but it doesn't do everything that insurance does as well. The best way to protect your assets is through what we call a layered asset protection strategy. One of the best things you can do is to both have insurance, good commercial insurance, particularly for rental properties, and also have an LLC that provides you both privacy and some actual protection through what's known as charging order protection. Myth number 9, LLCs give you absolute asset protection. I wish this were true, but it's just not the way it works. Sometimes members and managers on an LLC can actually be held liable for the actions of the entire business. This is a concept known as piercing the corporate veil. In fact, it happens all the time. If you fail to follow all the corporate formalities of your state's LLC laws, or if you just really treat it like your alter ego, then I can tell you right now, it's really not that hard for an attacking attorney to pierce the corporate veil of your LLC, and now you're fully exposed. Myth number 10, single-member LLCs will protect me. In most states, single-member LLC provides you no protection. I see this happen with CPAs all the time. A CPA will offer to set up your LLC for you, but in order to make it more tax advantageous for you so that you don't have to file a tax return, they'll set you up with a single-member LLC. Unfortunately, a CPA doesn't know what a lawyer knows. And so as a result of that, what you may not be aware of, it's very likely that you have set up an LLC in a state for which there is very little, if no protection whatsoever. So I want you to understand, one of the best ways to use a single-member LLC is to use it in tandem with a holding company. If you use that single-member LLC, but have it held not by you, but instead held by the appropriate holding company strategy, now you can both have tax efficiency as well as privacy and charging order protection. You really can have your cake and eat it too. Myth number 11. Registering my LLC name will protect my business name. I see people get confused by this all the time. They think by registering an LLC name, it provides them trademark protection for their business name. Forming an LLC does absolutely nothing to protect your business brand, your personal brand, or your business name from being used by someone else. Myth number 12. The LLC's corporate veil provides unlimited asset protection. I saved this one for one of the last ones because this is one of the most common misconceptions about LLCs when it comes to asset protection. Now look, it is true LLCs have what's called the corporate veil, which means there is some protection from an LLC in some states. But I want you to understand that veil is not always durable and it's very penetrable. Myth number 13, corporations are a safer business type than an LLC for protection. Now look, this is just a common misconception because LLCs don't mean limited liability for nothing. Think about this for a second. Limited liability companies can be one of the most flexible but yet also protective means for establishing your asset protection. Corporations can also be effective, but they can also mess you up sometimes when it comes to taxes, and you're not always as nimble or flexible as you can achieve through an LLC strategy. Remember, A limited liability company does one of the main goals of asset protection. It separates your ownership of your assets from the control of those assets. And if it's set up properly and you do it through the assistance of an attorney that knows what they're doing, you can both be flexible for taxes, be flexible for lending if you're a real estate investor, and you can make sure your assets are totally protected. For a deep dive on how to use LLCs the right way to protect your real estate empire, check out this video. I'll see you there.